Welcome, friends, to the Probate Nation. Our show tonight continues the discussion on dealing with guns in probate. You know, firearm ownership is very common in the United States, and in fact, there are no doubt tens of millions of guns filling gun safes, closets, nightstands, and desk drawers in homes and businesses all across this country. Regardless of whether you think that is a good thing, there is a chance you will discover your loved one owned one or more firearms at the time of their death. In part one on dealing with guns, our guest dove into the hard law that regulates some but not all of the guns you might encounter in probate. In part two, we will do a quick review of those key points covered so far, and then jump into two case studies to illustrate the application of the law to practical situations. We are fortunate to have back as guests tonight attorneys Dan Peterson and Ben Inman. They will lead the discussion in part two. Let me tell you again about Dan and Ben. Dan Peterson is an attorney in Fairfax City whose practice consists almost entirely of firearms law. He represents individuals, companies, and groups in firearms, regulatory matters, and Second Amendment cases dealing with the right to bear and keep arms. He is a member of the bar in Virginia, D.C., Texas, and Iowa, and is admitted to practice in most federal circuit courts of appeal and the United States Supreme Court. Ben Inman is the founder of Inman Law in Tyson's Corner. His practice focuses on estate planning and administration, including firearms and cryptocurrency-related matters. He is a member of the National Academy of Elder Law Attorneys, as well as the American Gun Owners Alliance. Please welcome back Virginia attorneys Dan Peterson and Ben Inman. Guys, thanks for coming back to help us continue this discussion as we go into part two. Dan, I'm going to come to you with, let's review for our viewers some of the firearms that folks typically have.
Sure. The most common, of course, is standard rifles, pistols, revolvers, shotguns, that type of thing. Guns that basically shoot only one bullet for every pull of the trigger. But then you also have things like machine guns, which continue to fire as long as you pull the trigger back or you run out of ammunition. Then there's some specialized items such as suppressors or silencers, short-barreled rifles, short-barreled shotguns, and what are known under federal law as destructive devices, which are mostly things like bombs, but also include some large caliber weapons.
Oh, wow. Now, we learned in part one that there are a slew of federal laws governing these guns, including the National Firearms Act of 1934 and the Gun Control Act of 1968. Ben, tell us what guns are governed by the National Firearms Act of 1934.
Sure. So firearms governed by the National Firearms Act are machine guns, which includes fully automatic weapons as well as select fire or burst fire weapons. And you've got short-barreled shotguns, short-barreled rifles being ones with a barrel of less than 16 inches and an overall length of less than 26 inches, as well as for shotguns, a barrel length of less than 18 inches or an overall length of less than 26 inches.
Thank you. So we learned in the part one that there are a host of common problems that arise with guns being probated. So Dan, I'm going to come to you. Talk a little bit about the problems that you see people encounter as far as the ownership of guns, proving their ownership.
I would say that really that's an issue for NFA weapons primarily. You don't really have to keep proof of ownership of an ordinary handgun or rifle, but you do have to have proof of that if it's an NFA regulated item such as a silencer or a machine gun.
And Ben, I'm going to come to you now. So talking about proper registration, what are the types of problems that you see arise in the course of an estate administration regarding the proper registration of a gun?
So one of the things is just sloppy record keeping and not making sure that all of your documents are easily found. Everybody realizes kind of in the abstract that someday they too are going to die, but not always do they make appropriate preparations for that eventuality. And sometimes the heirs and the executors aren't able to locate that paperwork, which can just turn into a major headache for them trying to sort out.
I think that's a very good point. And frankly, that's part of the work I think that our audiences should do with their friends and family who they know are getting elderly, who might very well have guns. Make sure they have the proper paperwork in place, and if not, start the process to see if we can locate that. Now, Dan, I'm going to come back to you and talk about some of the common problems that arise in probating guns related to transporting the guns to the heirs, whether it's by, their heirs by will or by intestate succession. Talk a little bit about those common problems, Dan.
Sure. I think the biggest issue, there's two issues actually, which are pretty serious if you are going to be transferring or transporting guns from the estate out of state. And the first major issue is there are lots of guns that are legal in Virginia that are not legal in other states, in some other states, let me put it that way. For instance, the popular AR-15, there's something like 25 million of those in the country. And a lot of them are in Virginia. They're perfectly legal here. But in other states, such as Maryland, New York, Connecticut, let me see, California, Hawaii, one or two others, those guns are actually illegal in those states, and you can't transfer them. Same thing with high capacity magazines, so-called. Most common limit on the number of cartridges that can be held in a magazine, legal limit in some of these states is 10. And many modern pistols have magazines that come standard with magazines that hold more than 10 rounds, so that could be easily encountered. The other thing that you would have to consider is to make sure that if it's an out-of-state person, and this is true in-state as well, but that the person is legal to get those guns by age, by special requirements that may exist in other states, such as licensing or registration of the guns. Those can be real problems, and they need to be looked at very carefully.
Okay, those are all good things to remind ourselves about. Ben, I'm going to come back to you now with the talk a little bit about gun transfer tax issues. So, are there any federal tax obligations that have to be addressed in order to transfer, a gun either by sale or by bequest?
Sure. So the most important one, and the one you're most likely to come into contact with, is going to be the National Firearms Act, which is that $200 tax stamp we talked about earlier. It's a $200 tax on the transfer of any NFA items such as a machine gun, short-barreled rifle, short-barreled shotgun, destructive device, or what they call any other weapon. So that's a $200 tax stamp that has to be paid. There is, the exception for bequests to that. Other than that, you've got things like the Pittman-Robertson Act, but that's not one that executor or administrator is going to run into because that's paid before it ever enters the actual stream of commerce.
What if I have an NFA gun without a tax stamp on the paperwork?
Well, first of all, having an NFA item without having the proper paperwork is potentially a felony, punishable by up to 10 years in prison and a $250,000 fine.
Well, that's not good.
Certainly not, especially if you're the one holding it. So you want to avoid that. Make sure the paperwork's there. You can try and get duplicate paperwork from ATF as long as it was properly registered with ATF. Weapons that were not properly registered and fall under the NFA can never be registered. Once it's, an unregistered NFA item that hasn't been registered, it can't be entered into the NFA. So,
well, that would be a problem. I guess that's something we want to find out about now. If mom and dad are alive and they own some guns, we want to get that straightened out. Now, I understand that if they have the tax stamp on the paperwork, that then I can undertake to go ahead and do the paperwork if I want to sell it. filing what they call the Form 4 and then go through the process to get that and pay your transfer tax. Dan, I'm going to go to you though. Does the executor who has filed that paperwork to sell the gun, do they have to wait for the NFA to approve that paperwork before making a transfer?
Yes, absolutely. And I should emphasize that it's the physical transfer and possession of the gun that counts. That's what ATF looks at. And in addition to that, once that paperwork does come through from ATF, the executor should transfer the gun as soon as possible, because it would, technically speaking, be illegal for the executor to hold it at that point in time. Don't wait a month.
Oh, wow, really?
Oh, yeah, and because you've got possession of the gun still, and the paperwork's not in the name of the executor anymore, it's in the name of the beneficiary.
Now, Dan, I know you've dealt with guns a lot in your practice. Are there a set of circumstances you come across where it makes sense to just surrender the NFA items to the ATF?
Yes, there's two instances. I mean, you could just voluntarily turn it in and they would take it, most likely. But I don't know if that would be a good thing to do if you have a fiduciary obligation as the administrator or executor of the estate. There could be instances where it's discovered that the paperwork is out of order, and you can't keep the gun anymore, and it would be advisable either to destroy the gun, or ATF would probably accept it under those circumstances if you had a plausible story. You know, it wasn't mine to begin with, here it is, and now I don't know what to do with it, so will you guys take it?
Sure, okay. Well, that's good to know, because we don't want to get in trouble with the ATF. Now, Ben, I'm going to come to you and talk about the Virginia gun laws. Does Virginia have any requirements to register a gun?
So most firearms, no. The one exception to that is machine guns. There is a requirement that machine guns must be registered with the state police.
Okay. And does Virginia have rules regarding the transport of guns that we should know about?
Absolutely. So the most relevant one for transport of firearms is going to be concealed carry of one of these firearms. And so something that's hidden from common observation on or about the person is going to be something that could be a violation of the concealed carry law in Virginia. So there are exceptions to that for, latch compartments in a vehicle. There are, or if the firearm is unloaded and securely wrapped. So that should cover a lot of the scenarios in which a firearm needs to be transported within the Commonwealth of Virginia.
So let's take a look at our first case study dealing with the pre-death gifts of gun pre-death. Okay, so up on the screen we are going to show the facts that we're working with. So we have a widow and mother of 3 children who has the following guns, which she inherited from her husband, who is recently deceased. Got a shotgun, a .45 pistol, a rifle with scope and with no scope, an AR-15, a short barrel rifle, and a silencer. Mom is 70 years old, has no interest in the guns, and wants to either give them to 2 of her sons, give them to her sons, or one of her grandsons. Let's review, though, some of the concerns and challenges these guns present for Mom to make the gifts she proposes. So, Dan, I'm going to come to you. What guns that we, in our example here, are subject to NFA registration and transfer rules?
Well, the 2 things that are listed, or the half dozen or so things that are listed, the short-barreled rifle and the silencer would be subject to the National Firearms Act rules.
Okay.
And AR-15 is not. They're perfectly legal in Virginia and in most states. That's a semi-automatic version of what was the M16 or the M4 in military service, but they're different in that they're not automatic fire or burst fire.
So the rest of the guns are not subject to NFA registration and transfer rules. So Ben, talk a little bit, we chatted a little bit about this when we were preparing the show, about the use of disclaimers in order to kind of move who inherits guns either by will or by intestate succession to somebody else who really wants the guns as opposed to someone who does not want the gun. Can you talk about that a little bit, please?
Yes, Richard. As a matter of fact, there are issues related to potential disclaimer, assuming that the probate estate is still open and mom hasn't received the distribution from the estate of those firearms, because at that point there will already have to have been the forms filed and approved with ATF. However, it's a different situation if probate is still open and there hasn't been a distribution of those firearms. Then there's the potential that mom could disclaim her right to receive those firearms, and then they would pass as otherwise dictated by the will or as dictated by the laws of intestate succession. So in this example, we'd be talking about having the sons then have the ability to inherit the NFA items instead of mom if mom disclaims, and then you can have a disclaimer by one or both sons or an order by the court as to who's to receive which NFA item, and then prior to the distribution there has to be an approval of the ATF Form 5 transferring those firearms from the estate of dad to each of the sons. Each son's going to have to file his own paperwork for that.
Okay, that's important to know, and I think it's important to reiterate, so I'm going to come back to you, Dan, because I know you've chatted about this a little bit during the course of both of these shows, is assuming that mom does not want these items and she files a proper disclaimer, depending on whether the sons are to receive the NFA items or whether or not grandsons are supposed to receive them, do we have to walk through a process with both of whoever's going to be the ultimate recipient to determine if they are allowed to receive them in the state that they live, and then go through transport rules? Can you respond to that, Dan?
Sure. I guess bottom line is that whether it's in state or out of state, you always have to make sure that the individual, it's legal for them to possess those guns in that state, and also magazines too, to be sure, if they're high capacity and they're going to go outside of Virginia. In Virginia, there shouldn't need to be a background check as long as it's not a sale. That applies only to sales between private parties, and since this is presumably coming from the estate or as a gift, the background check laws would not apply. You would want to make sure as well that if anybody lives outside of Virginia, that not only the individual is entitled to receive these guns, but also that the guns or magazines themselves are legal. Okay.
Now, Ben, I'm going to come back to you. Would the ownership of these various firearms, whether they're NFA firearms or not, if they were owned by a gun trust, would that be helpful here in allowing things to be transferred more easily?
Yes. Like other trusts, you get the ability for there to be an immediate successor, whoever's named in the trust instrument as the successor trustee and the successor beneficiaries after the settlor. They're able to take possession of those items under the NFA items without having to worry about any of the complications that you would have if they were owned by an individual.
That's good. That's good. And I'm going to continue on with case study number 1 and go to case study number 2. Dan, I'm going to come back to you. Mom has died. She hasn't. The guns haven't been transferred. She took possession of the guns legally. They transferred into her name. She now has died, owning all of these firearms. Okay. Can you just kind of walk through issues related that the executor needs to be concerned about, NFA concerns that arise for you, Dan, so we can go ahead and wrap up case study number 2.
Sure. So she's died testate. Let me make a distinction here. If mom has gotten possession of these guns and the estate is still open, the laws that we've talked about so far about transfers to people out of state having a federal exception that to the rules against individuals transferring that, that only applies if the guns are coming from the estate, not if they're coming from an individual. So we need to make that distinction. So Mom has now died testate owning all of these firearms individually. So there is an estate to open here. You know, then more or less the same rules we've been discussing would apply here. The executor can't be a prohibited person. ATF items, NFA items have to go through the ATF paperwork process. I would say that those are the major issues.
Okay. Well, let's go ahead and turn to some real life stories. And let's talk about some of these particular items that I know in preparing for this show, Dan, I know you had some stories that you could share, talking about a gun that might have had the registration number scratched off. Can you talk a little bit about that?
Sure. This was just an odd thing that happened to me personally quite a few years ago. An acquaintance of mine, we both shared an interest in firearms, and he was wanting to sell one that he had gotten from his roommate. It was an unusual gun. It was a World War I era .45 automatic pistol, and it was made by a manufacturer other than Colt, and some of those can be very valuable. So I said, yeah, sure, bring it by, show it to me. So I took a look at it, and of course the thing was in terrible shape, but also the serial number, all guns are required to be serialized, had been ground off by somebody or filed off of there. And those things are walking felonies. You can't it's illegal to possess a gun that has an obliterated serial number. So I had to say, thanks, but no thanks on that one. So if in an estate you find a firearm without a serial number, it may be a problem. It will be a problem if the gun was made after 1968. Before that, it was not a legal requirement.
Okay, well that's good to know. Now Ben, you also shared a story, because we've mentioned gun trust a couple of times. You've also shared a story with us about how gun trust can go awry. Could you talk a little bit about that, Ben?
Yeah, absolutely. So one of the ways that a gun trust can go awry is someone establishes a gun trust, they purchase NFA items, the NFA items are approved and transferred to the trust, and then the person who bought those items or who was in charge of the trust, the settlor, doesn't take good care of the trust paperwork, and it gets lost or misplaced, and then something happens to them. You can run into difficulties with, now there's this NFA item that's owned by a trust, but there's not a whole lot of clarity as to who has the authority to act for the trust, who has authority to take possession of these items, and it really demonstrates the need to stay organized, especially if you're going to own NFA items.
Well, guys, this has been a great, these stories, there's other stories I know we talked about, which I have on my paper here to talk about, but we're running out of time. So I'm going to go ahead and jump to closing comments. And so, Dan, I'm going to come back to you. You know, we've covered a lot of material here, and I know there's some things maybe that you would like to stress to the potential executors or heirs of estates about dealing with guns in the course of probate. So can you share some thoughts, Dan?
Is that Dan or Ben? Sorry.
That's Dan.
Okay. Sure. I mean, I think Ben has stressed the necessity of staying organized and don't losing your paperwork and that kind of stuff. I don't know that he mentioned this, but it's not a bad idea to keep an inventory of your firearms, particularly your NFA items. For out-of-state transfers, I mean, we do have to make a distinction here always between whether it's coming from an estate or whether it's coming from an individual, because the rules are quite different. There are exceptions for certain estate transfers, or in Virginia for the background checks for things that are gifts or obtained for free from an estate without a sale taking place. So those are some fundamental distinctions that we need to keep in mind for practically everything here.
And Ben, how about yourself? Some final advice, caution, tips for our viewers about guns in an estate?
Sure. I think I would definitely say that one of the things that you want to make sure you do, in addition to staying organized, like Dan said, is when you're not sure, ask, and also, seek out help when you're doing out-of-state transfers of firearms. It may be beneficial to go through a gun dealer who's accustomed to packaging and shipping these weapons across state lines, and just to know how it's done, how they're to be packaged, and the rules concerning that.
I think that's good advice, and I know Dan has stressed that as well when we were preparing for the show too. Go get someone, work with someone who's an expert on these matters. Guys, Ben and Dan, thank you both for taking the time to come back and finish up part 2 of dealing with guns. This is a topic that we're going to see more and more come to the forefront as the years go by, and great information for our viewers and for everybody in the probate nation. So thanks again for taking time to do this.
Thank you,
Thank
Rich.
you for having us on.
You're very welcome. Over the course of 2 shows, I've learned that dealing with guns in probate is not something to be taken lightly. There are federal, state, and local rules that need to be followed, and there are dire consequences should you fail to do so. As I said at the conclusion of the first show, and I reiterate now, if there are guns in an estate you are probating, it should immediately set off one of those warning bells you're likely to hear going off in an action movie when security is breached. The real life stories Dan and Ben shared of failed gun trust or trying to sell a gun with its serial number scratched off are examples of when that warning bell should ring even more loudly in your ears. While there are many tasks an executor can handle without an attorney, dealing with firearms is not one of them. From whether the executor can legally take possession of the firearm to whether the firearm is actually properly registered, to how the firearm can be transferred to the intended beneficiary or purchaser, and much more. All are questions that scream for the advice of an attorney knowledgeable and experienced with firearm laws. Because if you do something prohibited by law, unintentional or not, the consequences can be harsh. Friends, this brings us to the conclusion of our show. I hope you found it helpful. Replays of the shows can be viewed on the Probate Nation and YouTube channel. Until next time, make good choices and be safe out there.